Ladies and gentlemen, welcome to today's episode of Malaysia Crime Stories, where we will discuss the increasing sensationalized topic of child grooming. The process of child sex abuse begins with the process of child grooming, and today we will discuss this further. According to Roger Castillo, in his academic journal Not With My Child, he defines child grooming as a relationship of trust that is built between pedophiles and a child to engage in a sexual interaction from a non-sexual manner into a sexual manner in a non-threatening way. The specific definition of sexual communication and sexual grooming or child sexual grooming can be further found in provision section 11 to section 12.
In discussing the provisions of this Act, we will examine whether the provisions have been drafted clearly and if it provides sufficient protection for children against sexual predators. However, two caveats need to be informed in this episode. Firstly, on clarity. Majlis Agama Islam Wilayah Persekutuan and Victoria J.S. Lee Martin is a 2016 federal court case that affirmed the continued use and relevance of pepper and heart in our local courts. Now, Lord Brown Wilkinson commented, reference to parliamentary material should be permitted as an aid to the construction of legislation which is ambiguous or obscure to the literal meaning, which leads to an absurdity. Therefore, in evaluating the clarity that can be found within this Act, our team will evaluate the wordings of the provision by referencing it to parliamentary Hansards for debates on the Sexual Offences Against Children Bill. Briefly, the minister reading the bill in Parliament, Dato' Sri Azalina Dato' Othman Said, specified that the provision on child grooming was inserted to the bill to protect children and allow authorities to take action before anything regrettable happens. Therefore, the litmus test is to see if the wording, in effect, prevents or allows law enforcement to better protect children. Secondly, on defining what sufficient means. Now, Malaysia has ratified the Convention on the Rights of the Child in 1995. The Convention acts as a source of public international law which sets out the standards each state should aspire to when according freedoms and rights to children. We will examine if the Act meets those international standards to establish sufficiency. Where there are insufficiencies in the Act, we will draw comparisons to similar acts in New South Wales and Victoria in Australia, as well as the United Kingdom, with the hope that the best practices from these acts can be adopted in Malaysia. Throughout this presentation, we will discuss the Act in three parts. Firstly, the process of reporting an offence. Secondly, an attempt to prove an offence. And thirdly, what happens when the accused is charged with a sexual offence against a child.
Ladies and gentlemen, joining us in the studio tonight is a special guest who is none other than my close friend, Miss Isabel Chong. Anyway, Miss Isabel Chong is here to give us her insights about the reporting mechanism in Malaysia. Miss Isabel, I have a question for you. In front of me, I have the journal article by Nur Azlah Abdul Wahab entitled Mandatory Reporting Mechanism as a Preventing Mechanism for Child Abuse Cases in Malaysia. She claims that one of the main struggles in the Child Act 2001 in imposing a mandatory reporting mechanism is that common conceptions such as disbelief, lack of knowledge, or fear of the perpetrator themselves. Do you see these struggles improving in the current provision in the Sexual Offences Against Children Act 2017?
In Malaysia, with regards to the scope of the reporting mechanism of a sexual offence against a child, Section 19 of the Sexual Offences Against Children Act 2017 specifies that anyone who has information of the commission of an offence or the intention to commit such an offence but fails to report will have committed a crime. While this is commendable in making it mandatory to report, it does not list out all the incentives of reporting. Importantly, if the child grooming provision aims to prevent any form of abuse, children and parents alike have to be able to identify early signs of child grooming. In the United Kingdom, the Child Exploitation and Online Protection Command is a command of the National Crime Agency. They have formulated the Think You Know education program, which aims to empower children and young people to identify the risks they may face online, including child grooming, and know where they can go to seek support through education. In addition, the command has a reporting mechanism that can be accessed to allow the public to report suspicions of inappropriate sexual behavior or with a child online. In Australia, it can be seen that in the federal government setting up of the Internet Safety Advisory Body NetAlert educates children and parents about online safety by providing information and safety tips, and people can now contact its new online safety hotline. NetAlert has also organized educational programs such as the aforementioned United Kingdom Think You Know education program. Specifically, in the state of Victoria, a failure to disclose is now an offence introduced in the year 2014 that imposes a legal duty upon all adults to report sexual offences that have been committed on children under the age of 16. Generally, the identity of the reporter will be kept confidential. This provides an incentive for people to come forward and instead report suspected cases.
While the current legislation provides for mandatory reporting, it will only provide sufficient protection if it's coupled with education, anonymity in reporting, and immunity from protection when individuals report. This is consistent with Article 34 of the Convention of the Rights of the Child, which seems to suggest that government must take reasonable measures to ensure that children are not coerced or induced to enter into sexual activities.
Now we'll be discussing 4 controversial issues that will be presented by special reporters and trying to prove an offence under this Act.
The outcome report of Malaysia's second Universal Periodic Review suggests that 2 main observations that needs to be noted in establishing whether or not child grooming laws will be effective in this country. The first one is that the statutory minimum age for civil marriages for non-Muslim is at 18 years old. However, it must be noted that 16-year-old female may be able to marry with the authorization of Menteri Besar or the Chief Minister. This can be evident in Section 10 of the Law Reform Marriage and Divorce Act 1976. For the marriage between 2 Muslim parties, the minimum age requirement for a male should be 18 years old and female should be 16 years old. However, under Section 8 of the Islamic Family Law Act, Federal Territories Act, a Sharia court judge may give an exemption to such minimum requirement of age. This can be evident through the case of PP against Ridwan Muhammad in Sabah, February 2013, where a 40-year-old restaurant manager was able to rape a 13-year-old victim. However, he was able to marry the said victim to escape prosecution. The Sharia court, in allowing that marriage, said that he had no objection in granting the permission for marriage. This was exactly the concern that was raised by Datuk Teo Ni Cheng, the MP from Kurai, during the debate of the legislation of the Sexual Offences Against Children Act 2017. The primary basis for her raising this concern is that if the primary aim of child grooming laws or child sexual abuse laws was to prevent perpetrators from having physical or non-physical contacts with their potential victim, then she is unsure as to why it is not consistent with marital laws, where it literally grants the perpetrator a loophole to evade criminal prosecution by marrying off their victim. If we contrast this with the marital laws in countries such as Australia, where the Marriage Act 1961 in Australia has minimum age of 18 years old and only grants an exception to 16, this is drastically different than Malaysian Sharia courts, which can even allow individuals as young as 12 years old to get married. Coupled with the fact that in Malaysia there is no such laws that prohibits marital rape, an individual or young female who is forced to enter into such marriage may be forced to have sexual interaction with the husband, and the state will have very little to no regulation on said behaviors. As such, in Malaysia, marriage can also be a form of grooming because it can be used to manifest sexual interaction from a vulnerable party, or that party may include a child.
So,
Introducing the next special reporter, Mak Desi!
What are you doing?
I want to be taller than you!
Can you go?
in this special report, I will be discussing 2 additional issues. Firstly, on the application of Section 3 of the Act, which talks about extraterritorial offences, and secondly, on the inconsistency between the age a person can consent to sexual relations and the age by which we consider a person a child. On to the first issue. Now, Section 3 of the Act speaks of an extraterritorial application, which specifies that an offence can be committed by a Malaysian, be it in Malaysia or outside of Malaysia. However, it fails to address foreigners coming into Malaysia to groom children such that they become vulnerable to attempts of pornographic production and physical abuse. Dr. Manik Kure, in her article Child Pornography of the Internet and the Elusive World of Pedophiles, writes that the graphic details of the video footage of Richard Huckle abusing young children, which he then uploaded and shared in his manual called Pedophiles and Poverty, a Child Lover's Guide, also proves the fact that Malaysian children are susceptible to accosting predators on the internet that come from different countries into Malaysia. This is indicative of the fact that the current Section 3 on the extraterritorial application only concerns Malaysian citizens but fails to also include foreigners that come into Malaysia. We were lucky that Richard Huckle, upon returning to the United Kingdom, was charged under the Sexual Offences Act 2003, but this may not be the case for many other countries. As a result, we recommend that Malaysia follows the Crimes Amendment Record Grooming Act 2014, where in Section 49B of this Australian Act details provisions which state that an offence merely needs to be committed within the territory of the state, independent of where the accused is originally from. This is particularly important because it keeps in line with Article 34 of the Convention on the Rights of the Child, which speaks of protecting children from all forms of sexual exploitation and abuse, which also includes by protection from those who can commit these acts. Currently, where the Malaysian Act does not acknowledge foreigners coming into Malaysia, we can safely conclude that it does not meet the threshold of sufficient protection. Now, the second issue which I will be addressing concerns the age by which we recognize a child to be able to consent to sexual relations and the age by which this Act attempts to protect children. Specifically, this Act states that a child is anyone below the age of 18 and would fall under the jurisdiction of this Act. However, it seems to be inconsistent with the Penal Code, where in subsection 2D, section 376, a person is said to be able to consent to sexual relations by the age of 16. Now, when the bill was being read in Parliament, the Minister of Law, Dato' Azalina Othman, dealt with this issue rather unfairly, in our opinion. Because in the quest of ensuring children are protected at all costs, defences like the Sweetheart Defence or the Romeo and Juliet Defence have been omitted from the Act. Two teenagers between the age of 16 and 17 may consent to sexual relations. However, under the present Act, one of them will have committed an offence. It is especially important because many forms of communication may include said individuals texting in a sexual nature, which could include the exchange of nude photos as is the current norm, or lead to physical exchanges. Unsuspectingly, while the law attempts to be noble, it has become unpragmatic as it converts recognized consent into an offence. Dato' Azalina did propose a mechanism to deal with this, and that was to grant the public prosecutor enough power or discretion to decide which cases that fell between these groups that needed to be charged. The increased amount of discretion granted to the public prosecutor can increase rates of indiscriminate prosecutions, where some cases lead to a prosecution and some do not, which could as a result lead to an inconsistent application of the sections of this Act. As a result, we propose three suggestions. Firstly, it could be reasonable to raise the age of consent to 18 and as a result allow the current application of what constitutes a child based on this Act to be active. Secondly, we could exclude those from the age of 16 and above out of the jurisdiction of this Act. However, what is more probable to be done is to consider what NGOs like Voices of the Children have advocated for, and that is for the simple inclusion of the Romeo and Juliet defences, such that these teenagers may not be unfairly prosecuted under the law. In conclusion, whilst the Act is noble in suggesting that it should protect children at all costs, if some teenagers and children are unfairly prosecuted, we think this does more harm than do give protection. Rakshana,
Oh, hi. I will be now presenting on the Spinal Special Report that concerns disabled children. Dr. Liang Teck Meng, the Member of Parliament for Simpang Renggam, lamented at the second reading of the bill on how do we adequately protect disabled children who may have difficulties communicating their experiences. Because this means that if the intention of Parliament upon creating the Sexual Offences Against Children Act 2017 was to protect all children from sexual offences, then the Act should also be about protecting children who face physical or mental disabilities. In the United Kingdom, Section 30 to Section 37 of the Sexual Offences Act 2003 creates two new categories of offences to protect persons with a mental disorder or learning disability. The first prohibits involving a person in sexual activity where that person, by reason of mental disorder or learning disability, is unable to refuse. The second category of offences criminalizes involving a person with a mental disorder or learning disability in sexual activity by inducement, threat, or deception. These offences recognize the fact that although such a person may be quite capable of giving his or her consent to sexual activity, he or she may nonetheless be vulnerable to relatively low levels of inducement, threat, or deception. The Sexual Offences Act 2003, however, is silent when it comes to children who are physically disabled. In Australia, the Royal Commission into Institutional Responses to Child Sexual Abuse has drafted a report to highlight the importance of protecting children with disability. Because we all know that children with disability face additional barriers to disclosures. Although Australia has yet to have legislations that addresses protection for children against sexual offences, most states in Australia have their own state statutory agencies that protect children with disabilities. For example, in New South Wales, the Ombudsman conducts trainings and handles issues relating to abuse and neglect of the disabled. In Victoria, the Victoria Police have guidelines for people to report criminal abuse of children and vulnerable people, and these vulnerable people include disabled children. Therefore, Malaysia should have provisions that protect children with disabilities because they are often vulnerable and have difficulties communicating their experiences. By having provisions that protect disabled children, this means that Malaysia will be able to meet the requirement in Article 2 of the Convention where children should be protected by laws without discrimination to their disabilities. After the offence has been proven, the Sexual Offences Against Children Act 2017 provides rehabilitative counselling under Section 26, and the rehabilitative counselling will last as long as the convict's period of detention. And according to Section 27, offenders under this Act will be under police supervision for 1 to 3 years immediately after completion of the sentence. This means that a person who is guilty of child grooming will be under police supervision once he has completed serving his sentence. However, this can be improved if we adopt a sex offenders registry as mentioned by Datuk Sri Dr. Haji Irmohizam bin Haji Ibrahim, the Member of Parliament of Kuala Selangor. The sex offenders registry was also proposed by Azira Azim in her journal article entitled Child Sexual Abuse Prevention in Malaysia. She said that the establishment of this registry is for the purpose of screening sexual predators and restricting access to children by keeping a list of accused in ongoing court cases and convicted sex offenders, including the type of offence and sentence served. In Australia, the Sex Offenders Registration Act 2004 prohibits sex offenders from getting child-related employments. This also includes clubs and associations that provide services or conduct activities that are directed at children. Registered sex offenders are also not allowed to apply for children-related employments, and if they do so, they would face a 2-year imprisonment penalty. In Malaysia, on May 2015, a proposed sexual offenders registration bill was shelved despite bipartisan support of its legislation. It is strongly recommended that the members of parliament revive the sex offender registry system as a tool to screen sexual predators from potentially committing child sexual abuse in the very places they were meant to be safe, and this includes schools, religious institutions, and even our homes. Dato Sri Dr. Haji Irmohizam also suggested that sexual offenders should not be within 1,000 feet from school compounds, children playgrounds, and child daycare centres. At the same time, he also suggested that sex offenders should not work in sectors that involve children, and this suggestion is similar to what Australia's Sex Offenders Registration Act 2004. In conclusion, ladies and gentlemen, it looks like the rainy season is not over for the convicted. And that's a wrap for Malaysian Crime Stories. And since it's the 4th of May, may the 4th be with you.
Guys, I think throughout the series we have actually covered a lot of criticisms about the legislation and where the legislation falls short and what the improvement that is necessary. Do you think that we should also include a conversation on what good things the law already covers?
I feel that in order to achieve a more balanced discussion, we have to point out the good points that these child grooming provisions in this new act provides. Section 11 and 213 uses a broad definition to encapsulate what constitutes grooming. However, in the process of proving an offence, two potential problems may arise. But I think that the act sufficiently deals with these problems. The first problem is other than the offender, the child is the only party that is privy to the communications made between the offender and the victim. And the second problem is that it may be difficult to obtain information on this communication due to technological advancements nowadays.
So you're saying like when it comes to technology, things like end-to-end encryption in WhatsApp or like Snapchat not being able to save data means it's very hard to acquire this information, right?
Yes.
But isn't allowing the child to give evidence in court a good way that this act deals with these issues?
Yes, I feel that in this act, Section 17 and Section 18 sufficiently deals with this problem, and it provides for the capacity for the child to provide evidence, uncorroborated evidence in court. In the Evidence Act in 1971, Section 133A provides that a child can only give evidence, but it must be corroborated by material evidence implicating the accused person, and this was provided for in the case of Muhammad Terang bin Amit and against the public prosecutor.
Okay.
And this new change in the law actually allows Malaysia to accede to Article 12 of the Convention of the Child, which allows children to have the opportunity to be heard before a judicial proceeding. Currently, this provision meets the international standards regarding how children should be treated.
So you were saying there was something else that was good about this act, right?
Yes, actually, anyone above the age of 18 cannot be ordered through bond or good character test to be released early prior to their the fulfillment of their sentence. This means that they must finish the full sentence, and this is supported by Datuk Seri Dr. Ronald Kendi in his parliamentary debate for this bill. And I feel that the inclusion of this the provision, we can see that Malaysia places a much more significance on sexual offences against children rather than putting it on the same plane as the other criminal offences.
The one final thing though I wanted to add is on the existence of the agent provocateur section, which is section 22 in this act. Now this meets the standard set in section 5 of the Crimes Amendment Sexual Procurement for Grooming of Children Act 2007 in Australia, where they have allowed people to go undercover as fictitious children to hook potential perpetrators so that they can be brought out much earlier from before they even reach to grooming actual children. Similarly, we can do this now in Malaysia, and I think this is quite important because if we really want to prevent, based on the intent of the act, prevent children from being abused or being exposed to grooming, sting operations need to be carried out. That means going undercover, speaking to these individuals and making sure when they've used certain types of language that can be identified as grooming, they are then charged under the act. The importance of this is to ensure children themselves don't need to be exposed, and it also avoids situations where in the instance of rage, they sent a reporter to be undercover, and that reporter acting as a 15-year-old could not use that evidence because the bill had not been gazetted yet. And I think this changes the future by which how this law is implemented in Malaysia.
Ladies and gentlemen, thank you for watching today's episode of Malaysian Crime Stories. In today's episode, we have extensively covered on the issue of child grooming on two specific areas. Firstly, clarity. With regards to clarity, our team has made reference to the intention of the Parliament when the bill was actually being legislated. Secondly, with regards to the issue of sufficient protection, we measured whether or not the current legislation meets the standard that is spelled out in the Convention of the Rights on the Child. We have also realized that the law or the legislation is operative in three different phases: before the crime, during the crime, and after the crime. And where we made criticism on these specific areas, we have compared or referred to more mature democracies or legislation on specific areas such as the United Kingdom and Australia to best recommend their best adopted practices to be adopted here. Ladies and gentlemen, that marks the end of today's episode. We hope you enjoy educated, and most importantly, informed.
Thank you.